I hear some inventors mention they have multiple patents on their invention. Can you explain why this happens? Wouldn't one utility patent give enough protection? Well, as it turns out, in order to get the broadest rights possible for a patent, for an invention, you almost always want to try to get multiple patents and cover what's called a portfolio. So during examination, several things can come up. When you first file a non-provisional, if your claims are a bit broader than they should be, or we're asking for more than you sort of deserve in a way, the examiner could say, look, you've actually got more than one invention here. And they could say, you've got to pick which invention, right? Either it's the device or the method of using the device is a pretty classic example. And so usually you want to go for the device, right? That's going to be the broadest rights. And so you do an election. I'm going to elect to move forward with the device. So before that parent application on the device gets granted, you want to file what's called a divisional patent application, and they will run in parallel, covering the method of use. That's an easy way to sort of build a portfolio through divisionals, where you actually have separable inventions. The examiners don't want to conduct a search on, both inventions, right? They're not being paid for that, so they're sort of in a way making sure they get paid for each application. Another great way is just before the parent issues is when you get a notice of allowance, right? The big celebration time, the examiner says, yep, this is good to go. This is novel and non-obvious and has utility. We're going to be able to grant this a patent. Before it gets issued, you've got the ability to file a continuation. If the parent issues, right, it gets granted, you no longer are able to file a continuation. And what a continuation is it allows you to take a sort of a second bite at the apple. And let's say you got that device, but during the pendency, right, which could be a year and a half, 2 years sometimes, while it's under examination, you might have come up with a new version, some new improvements, or ways that your customers love it, but it wasn't actually included in that original filing. Well, it's a new improvement, right? It's an option, or it's a new improvement. So you want to be able to protect that as well, and you can using a continuation or a continuation in part. And that's a child patent, it's called, from the parent, but it must be filed before it gets issued. Otherwise, your original parent filing will act as prior art against you on any similar filed situation. So a little bit complicated on the answer, but thank you for bringing that up, Brian.